Good evening and welcome to Slam the Gavel, the show that tells all regarding family court, other court issues, as well as CPS. I am your host, Maryann Petri. You can find me, my books, and blogs on dismantlingfamilycourtcorruption.com. I have a return guest on. I have Nate Munro. He was last on season 5, episode 167 and 180. He is joined by Rosemary Von Gorder, and we're going to talk about how difficult it is to vet people that we talk to as advocates. And I welcome you both, Nate and Rosemary, because we're going to talk about the Ballard issue.
Thanks for having us back. I appreciate it.
Thank you so much. I'm glad you're back, and we got a lot to discuss here. So I'll let you take over for a little bit here, because we've got a situation here with Jacqueline and Danielle Ballard.
Right, and we just need to clarify some things
Mhm.
from Amber Jones's perspective. Amber Jones is the mother in this case. Jacqueline Ballard was the grandmother in the case, basically, and she had accosted um, Amber's two children and taken them out of the state, and they were living on the lam there for about, I guess, 9 months or so. And so when we helped with Amber originally, I was working as part of a team, and Amber was one of our parents who we were all helping. Rosemary came in about, I guess, about a year into it. I helped out until Amber had gotten the kids back into at least CPS custody. So while they're being searched for by the U.S. Marshals and such, I was helping her, trying to keep things together and work with her. I guess Rosemary actually started working with Amber while she was in Larimer County, which is where Rosemary lives and is focused on mainly for her advocacy efforts with a lot of the cases up in Larimer County. And that keeps her busy a lot of the time. I suppose I can pass it over to Rosemary to kind of fill us in on where the case is currently.
Mm-hmm. Well, just briefly, um, this is a Delta County case with ties to Larimer County. Grandma got custody in 2018, but based on
Rosemary, it's broken up or almost frozen now.
false pretense, unvetted allegations, and assistance from Larimer County to help set up. So, grandmother was given custody without notification, service of legal process to the mother. Mom didn't know this hearing was happening, that grandma was in the process of filing this. Court granted her custody without both sides being present and the right to defend yourself. And that's how things started with grandma having custody. But over the course of mom fighting to get her kids back, the court ordered PRE, a parental rights. There were obvious concerns identified by the formal report back to the courts about grandma's mental stability. The court was about to grant mom her kids back. Grandma and sister absconded with the kids before the hearing the next day. So then it became where'd they go? How are the children? There was no communication, and the U.S. Marshals did get involved because there was crossing of state lines where the children were out of state. 4 or 5 years get involved. It's a federal issue. of a court order and failure to comply with a court order and violation of a custody order. Mm-hmm. However, in those charges, there's nothing that addresses the harm the children experienced. No child neglect, no child abuse charges, and mom is completely left out as being considered as a victim. The status by the DA who made the decision to offer this plea of charges is questionable, because by saying there are no victims that we need to be concerned about, it's considered a no VRA, Victims' Rights Act, duty to comply with the rights of victims. So this is disturbing, because whoever might have placed the kids in danger, that is taken off the table. To me, that says the Department of Human Services is avoiding liability by being in the position the DA has set up for them. No victims. We don't have to tell them, notify them, run stuff by them, because there was no harm, but there clearly was. And as a result of this reunification, thank God, almost a year ago now, after the marshals found and brought the kids back, they will be returning home to their mother a whole year later, which will be soon, this Christmas. They'll be returning home to mom, where they belong.
Rosemary, what is the current status of the Ballard case?
Well, there was a pretrial hearing Monday for the Ballards, and a trial is set in February. Neither have attorneys. They're both pro se, and they will have a jury trial. However, going home to their mother before Christmas. We're thrilled with that.
That is...
yeah.
However, DHS is laying low on this.
They are. When the federal marshals got involved, that indicated that there was a federal crime committed, crossing state lines in violation of a custody order and failure to comply with the custody order, which was about to be issued right before Grandma took off. Nonetheless, the charges do not reflect any harm to the children in the care and custody of Grandma and sister. The Department of Human Services assessed the children, evaluated them when they were returned to their legal custody of the county, and there are some serious issues that have been confirmed by the kids. It's recorded, documented. However, the DA chose not to list them as victims, which takes the Victims' Rights Act off the table, which also relieves the county of any liability for the harm to the children and the mom in all of this by saying no victims. This is a mix between Larimer County being involved in assisting Delta County to get those children into Grandma's custody to begin with under false pretense. And it has also come up in Larimer County recently, and we'll get to that in a minute, what they're doing here.
Well, take it over, Nate. What are they doing? Because this does not sound good.
Well, as just to continue on with Amber Jones's case, I was removed when CPS came into the position on that case. And in general, once CPS gets involved, that can be one of the most dangerous times for families, quite honestly. Like even when they were out on the lam and running wild in the country, they were probably in less danger than once CPS gets involved, because CPS, their goal is always to take the kids away pretty much from the parents. I know it's always stated they're not doing that, but that is almost always their goal in that, which you can see through their actions, never mind what words they use. But there's certain counties that have bigger issues. Well, I've found most of the counties that we've investigated in Colorado have turned up severe issues of corruption, and Larimer County is one of the worst. So it's no wonder that Larimer County ends up being affiliated with parts of this, because they get their fingers in all kinds of things. As far as this case went, as soon as the CPS folks got involved, I was more or less removed. So I'm not as familiar with where the case has gone once CPS had it, because I was mainly helping Amber advocate for while the kids were on the lam and they had the U.S. Marshals chasing them. But and I do know that a lot of things had happened with the kids while they were gone. There was an issue where Jacqueline Ballard had tried to trademark the kids, which we'll probably need to get into on another podcast to dig in deeper on that. But that falls back to some of the points that Joe Williams was making on your podcast, Maryann, about how there's an interesting quality here where they will take people and consider them like stock options or corporations, or just start muddying the water with it. And it's not clear exactly what Jacqueline was attempting to do by trademarking the children. But as Rosemary can clarify and attest to, the judge in the case had said that the jurisdiction didn't apply to the family courts because they were trying to use a different court system. Can you help clarify some of that for us, Rosemary?
I think the argument they're both trying to make is that they are sovereign citizens, and the U.S. judicial justice system does not apply to them, that they are their own person and a person, but it's not recognized by the court system. And they need to accept that and realize that their defense is not going to get them anywhere. In fact, it's caused attorneys to step down, walk away, and it won't bode well. It's not going to hold water. Their stance on being sovereign citizens and therefore under their own jurisdiction as citizens. So,
Rosemary, can you talk a little bit about the treatment of the children while they were on the run?
Yes, I can. The kids were not attending school. The details of when they were in Oregon are a little cloudy, but when they had returned to Colorado and were flying under the radar, apparently the kids had no power in the house because they did not want the public utilities to recognize that someone was in the house. So they were in the dark. They were not bathing. You can just imagine that the whole thing of access to water and food and electricity, all of that was non-existent. They were not clean. I am anxious for the full report to come out, but with that, there should be criminal charges that have already, we're sort of past that point, but it's not too late. People can contact the DA in Delta County and ask, what is going on? Why aren't you really protecting these kids? There's more here, and there is liability, so don't avoid it.
Right, because I had done that podcast on September 30th on Bring the Babies Home and Close the Case with Jacqueline Ballard and Danielle. And I got some responses. It's hard to vet people when they're not up front or they're just telling you a really good line. And I'm sure they do this with the police too. They don't know what to do with some cases either until they get in there really deep.
Right. And law enforcement will sometimes rely on child welfare workers as the information providers, what do we got and what do we need to do about it? How can we help? But child welfare caseworkers are not trained investigators. They're not licensed like law enforcement is. So when law enforcement trusts that CPS knows they've got all the information, they need to be careful because it's often conjecture or assumption. And the preponderance of evidence is no standard when it comes to families. That should not be the standard of evidence.
Yeah,
More than likely not that happened.
Rosemary, in many ways, this mirrors many of the aspects from the Robin Nocetta case that I covered in the last podcast that I was on with you, Maryann, where with the written admission. In that part there, we were able to see how they conspire as a group. The caseworkers will work with their favorite GALs, who are guardian ad litems, who work as the attorneys, state appointed attorneys for the kids. They'll also work with attorneys from the ORPC, which is the Office of Respondent Parents Council, that provides the indigent parents with state appointed attorneys when they can't afford the representation for themselves. Those are both fraught with all kinds of issues already, just because the ORPC attorneys, they only will defend parents against criminal charges and don't really help them out making any forward progress on their case. So normally when you have one of those folks jump on your case, they aren't going to help you actually win. They'll help defend you from being thrown in jail specifically to some degree, but many times they're bad faith actors too, is what we've found in the trenches, where they actually will say nice things to the parents that they're supposed to be defending and then capitulate and work with the ops and the CPS workers and DHS workers to try and get the results that the DHS folks are after. And that's part of what was covered in the Robin Nocetta admission also, is they will take those people specifically because those GALs and ORPC attorneys will, and including judges, they'll also transfer to get specific judges that will give them the preferred results. So it's a collaboration effort from a lot of these different parties all working together. And most of the times the parents are completely unsuspecting and unknowing of this whole collaboration going on behind the scenes to take their kids from them. And that's a big part of the problem. There's a lot of similarities between how that written admission was admitting to the issues and what you actually find up in practice in Larimer County. Would you say that's true, Rosemary? You might go into a little bit, expand on that a little.
Are we case specific or systemic here?
You can talk about it systemically, I think, at this point, because we'll get into more of the systemic issues. But Amber Jones is just one more case in that system.
So sad.
Yeah. No, it is difficult to defend yourself as a parent. You're expected to cooperate, comply with whatever they throw at you in a treatment plan, which 9 times out of 10, maybe 10 out of 10, they're devised without the parent involved. And that's part of a federal requirement, that you sit down with the parent and work it out so that there's a higher level of success expected. Instead, the caseworkers hand it to the parent right before court. The court expects them to agree. A parent hasn't had time to go over it. Their respondent parent attorney encourages them, backs them into a corner to say, just go along with it and we can fix it later. We can just make the admission and it will then be court ordered that you comply. But if there are problems with it, we can come back and tweak it. Unfair. And then, if you can lose your children based on non-compliance with a treatment plan that you didn't help prepare and had no say in, or felt coerced to agree to it, how serious is that? A termination of parental rights because you did not comply with an element of the treatment plan. It's so subjective.
And this goes on every day.
Yeah, every day.
To the parents out there who, pardon me 1 second, Rosemary, to the parents out there who are in that situation, it is totally within your ability to draft your own treatment plan. And that's suggested at that point, because if you were not involved in the treatment plan being drafted the first time, you can argue that it's not a legitimate treatment plan because you were not involved with its drafting and the creation of it. And then it helps a lot, especially to frame the argument in your terms, to go ahead and draft your own treatment plan. And that can totally change the course of a case, just that one move right there, because that basically sets up the reintegration process to be able to be reintegrated with your family and to remove CPS from your case also. So those are both very useful aspects, and you can take the power in your own hands by drafting your own treatment plan and just introducing it to the court at that point.
Good, Nate.
Thanks. I appreciate that. Go ahead. Go ahead.
And Amber Jones is very fortunate that she will get her children back before Christmas. So where are the grandmother and the sister right now?
They're out on bond. They each had very high bonds, reduced to 50,000, and one was cash only, and someone came forward and helped with that, and the other was at any rate, they're both out on bond in the community. So that's a little concerning.
That is. We were talking earlier, it's a felony kidnapping charge that really.
Yeah.
Yeah.
That's what should be on the felony. It's violation of a custody order, not kidnapping. Should be maybe, a higher level of felony or added to it, but we're going to work on that. We're going to ask some questions.
Yeah, because a lot of parents will say, well, that's a felony kidnapping if they took them across state lines.
Yeah.
The trick that makes this difficult, Maryann, is I believe at the time the children were taken, Amber Jones, the mother, was her parenting rights were being contested at that moment. Maybe you can refresh my memory on this, Rosemary, because this takes me back a couple of years now at this point.
The only one contesting her right to parent was her mother. It was not the courts. There was not a CPS case. It was allegations strictly from a third party across the state saying these things, that you have an unfit mother and I need to be the custody, have custody of these kids. Well, where was mom's ability to defend herself? She was tricked into surrendering her kids to the father, who had an active protective order to stay away from the kids. But the department, this is a guy that had domestic violence and a standoff with several law enforcement agencies in Delta County when he had a mental health breakdown. Deep I should go, but there were clearly issues that he was not a fit parent and had placed the kids in danger before. But in order to get Amber to allow the kids out of her care and custody, he stepped in with a bribe/plea from Larimer County and Delta County combined to visit the kids. And as soon as they met in a park, away they went with the kids, and grandma was there to take them. So it's like, that's not a court order. That's not a vetted series of events at all. So I place some blame here with Larimer County and Delta DHS. If you back it up far enough, how did grandma get custody of the kids? And was it fair and legal? No, it wasn't. So
it's a fascinating case.
I think that's shown, though, because she left the state. Like, if that wasn't like a thing that you would do if you were confident in having custody of the children, right? You don't just go get a life on the road going. That's not a position you'd normally do.
Right.
So agreed. Part of this is really concerning about how the different DHS departments work with each other within the state too. This is another thing, and it goes back to the point where the oversight here actually works more as a oversight body to make sure the corruption can keep working correctly and covering it up, rather than oversight to actually prevent corruption.
Mm-hmm.
Right. The accountability is absent, and it's a system that is built around avoiding it. But they sure will pressure parents to make admissions, and under the guise of softening it, a no-fault plea or through no fault of your own, but you're still guilty. Therefore, we're going to take control. It's like, what is that? It's like really overkill on taking accountability when the consequences for being in family court are horrific if you don't play it right according to their rules. But they're never accountable.
No.
But that's the whole problem,
Yeah.
Rosemary, actually, is like what we were covering last time in the Robin Nacetta admission. They don't even care if you're actually doing your treatment plan. If you weren't doing the treatment plan, then they'll use that against you. But even if you do the treatment plan and achieve it and make progress in that, they will say that you did not, or move the goalposts, or do some other little funky maneuver where it'll be worked against you somehow. And once again, Rosemary has made a great point about the lack of accountability. All these fall back to the points I keep tying into, where all this bad behavior doesn't work as long as you apply the psychological fitness for duty standard that we have in Colorado. State employees, this is state and county employees, including judges and police and everybody. Any state employee in the Colorado region needs to be able to be psychologically fit for duty under this standard, or be removed from that position. And they don't exercise any execution of this at all, because they basically allow these crimes to go unchecked. And then even the supervisors will be involved with a lot of these. Now, I don't know if that's completely the case with the CPS case in Delta County now, with Amber Jones working with this. Rosemary, do you know anything more about that, about how the management's maybe contributing to this?
The original caseworker, the intake caseworker, is no longer there. But there's always a supervisor, and there's always case managers over every single caseworker. So, somebody had to be signing off on documents. Some judge had to sign off on that motion for temporary custody that gave grandma the kids without a fair hearing. So I'd like to know who that was.
Yeah, that's just terrible. And this goes on every day. Parents don't realize it until it happens to them.
Correct.
But by that time, once it's happened to you, the trap's already been sprung, and you're in the middle of a bunch of people, all with a concerted effort and converging interests, right?
Mm-hmm.
And that's the problem. You have all these people have agendas beyond returning the children home, and it ends up yielding really bad results for the families. That's the main point out of this.
Right. There's always trauma when they take a child out of the home. There's always trauma. The longer it goes on, it drags on for whatever reason. Always something new you have to do or didn't do right. Every day out of home environment is trauma for kids. And at some point, there's a breaking point. You don't recover from it, no matter. You carry it throughout your life, the trauma of separation.
From the ACEs scores.
Right. I've actually heard from the child psychologist from Colorado Springs that it only takes 6 months for a child to become permanently damaged psychologically from these issues. And 6 months is a really weird number, because when they use the family integration therapy, or FIT therapy, that's what it's called, at least here in Colorado, it works in 3-month increments, and there's like 4 or 5 steps to it always. So the policy is set up to be psychologically unsound and damaging to children just by the policy. So that's why it doesn't work. That's why it's so damaging. We can say it again, that if you take a child out of the house for whatever reason, that's damaging. If you jail a parent, it's doing the same thing and causing generational trauma there also.
Mm-hmm.
And that's why jail should not be used in these cases with family court. And it's part of the policy, bad policy that drives this whole thing in the first place, to create these issues, because the children that grow up from these situations end up growing up and trying to fix families within their own lives. So that means they'll have young families and they're uneducated to a lot of degree about how to parent a kid successfully, because they were denied that and were just traumatized and shocked repeatedly. And it creates this generational issue that's almost having a eugenics type of effect on our society. When you look at the way society has fallen apart in the last 20 years, this is a completely instrumental part of that, to create that. And it's when you break these family bonds, they don't come back. They get damaged permanently.
Mm-hmm.
And it ruins generations above and below whatever parent is in there. Like here we can see Amber Jones was involved with this. Now all of a sudden her mom got involved and she's messed up her thing. Now grandma's going to be in jail, maybe. Who knows what happens with all of that. But the kids' lives are just rocked. I mean, what the heck is all of this? Is like a Jerry Springer show that DHS and CPS introduced and inducted the family into it. I mean, they just absolutely are causing this and instilling these really bad parenting lessons for the families involved, including the kids who grow up and then repeat this cycle of abuse.
And I think
Do you have
that's
anything
what
to add
they want
to that?
that to, yeah, I think that's what they want to have happen. That way it
Right.
keeps the federal incentives to keep coming in.
Right. We'll get into part of this with the improvement efforts in Larimer County too, because this is a perfect reason why you might need federal funding for a study committee. Right, Rosemary?
The Child Welfare Study Committee?
Yes, that exact one, but others like it too, because there's lots of money that needs to be spent.
There's so much money in grants to pilot projects and
to talk about it, to talk about solutions and never implement them.
Yeah. And the last people that ever receive the grant funding and donations to families seems to be the parents. It goes to everybody else, foster parents, adoptive parents, for more recruitment and training of those people. And rare is it that parents can get access to stable housing when that's the issue, or transportation. I mean, it's not abuse and neglect. It's poverty.
Well,
that
but
might bring them.
The poverty is a result of the abuse and neglect done by the department many times.
Yeah.
Like, because like you can't say these cases are cheap. These are horribly expensive catastrophes to happen to a family, especially when we consider nowadays they often throw around that point like 60% of the population can't handle a $400 emergency. Well, this goes way beyond $400. I mean, and if you can't even handle a $400 emergency through the majority of the population, when you set these policies up to be used on 100% of the population, this means 60% are being entrapped. And that's the real problem. And in Colorado, it's really bad. They will try to use heating bills out, heating disconnects as a reason to come say, oh, your house is unsafe for these children. We've got to go take them and put them in foster care where they don't worry about heating bills, because they get the subsidies from the Title IV subsidies from the Social Security Administration. So it's like this horrible catch-22 that they can use against you.
Yes.
That's why I was talking about the 4 tiers of our justice system. Like, the laws don't even apply to the top end of things with the government and the elites, but then the working class people, who are the ones subjected to all these laws in family court, they don't pick on the families that show up with a lawyer because they know they can't. But the ones who don't have lawyers and come in pro se, they just kick them around the schoolyard all day long. And it's brutal to watch. Like, as an advocate, you watch a lot of this, and it's absolutely brutal. It's difficult to keep doing, quite honestly. Maybe we could take that moment to segue over to some of the other cases in Larimer County then.
Yes, that'd be great.
Was there anything else you wanted to talk about with that case, Maryann, to clarify things for the for your listening audience?
I think that's good. I think we covered quite a bit. I think we did great.
I did want to make one point that I don't know if we hit earlier, that I think one of the comments you had on that video for Jacqueline Ballard was referring to, this mom doesn't deserve her kids because she's a drug addict. Well, I need to inform everybody that under the ADA, the specifically the ADAAA, which is the Americans with Disabilities Act Amendments Act of 2008, where they broaden the definition of a disability, they've also included substance abuse as a disability. There is a caveat to that. As long as the individual is in some sort of treatment, it doesn't matter if they're successful with the treatment or having hot UAs or any of the rest of this, as long as they are in treatment and participating, they are protected under the ADA. And this is something that Rosemary touched on earlier, when the courts say, well, that's not within our jurisdiction. We run into that a lot with the ADA also. You have to be outspoken and voice your rights if you have them, because they will not tell you, and many times they'll try to denounce you and dismiss you even when you are saying things that are legally accurate. And it's very difficult waters to navigate. People. And one other point about just vetting parents, actually, or cases in general, this could be parents or DHS workers coming to you with their version of a story or whatever. Typically, if somebody has to remake a story and things change, that is somebody who's making up the story. However, PTSD survivors often will give you a story in many different little chunks, but mixed up, kind of a Pulp Fiction kind of delivery. And those cases are tricky because you get the things in the wrong order and not all the information at any one given time. But almost always with these PTSD survivors, these memories are like frozen in their brains. So they may be kind of spotty about how they recollect the whole thing. But when they come up with the different parts, they'll all fit together almost seamlessly. And they may mix things up like, oh, this was supposed to be first. I didn't have that in the right order or whatever. That's very common. But that doesn't mean they're changing the story necessarily, although you have to be kind of take it with a grain of salt too, because if they start doing that a lot, then you got to go, that doesn't sound like it's totally fitting all together. But typically when a story comes in, and even if it's in pieces, it still makes sense once it's added together. That's a difficult thing to do with a lie over time and have it supported by paperwork. Almost always you want to see some paperwork or something, or some receipts for people's positions on things, in order to just put those fears to rest that you're on whatever side you need to be on. But even if you don't take one side or the other specifically in a case, you can still analyze the case for legal inaccuracies that often happen with the judge or with the courts or with some of these other contractors like the GALs and the ORPC attorneys, because when they get involved, things will inevitably change some with that. So I think those are good ways to be able to kind of decipher some of these things, because quite honestly, from someone in your position, Maryann, where you're just trying to run a podcast all the time, you don't have the time to go do weeks of research for each one of these cases. You're just trying to help parents get some publicity for their cases because nobody else will. So I feel for your position in this too. And the people that you work with in these cases, they are professional liars, many of them, and they're very good at it. And it takes a while to actually see through these types of issues. And most of the time, the only way people get the experience to learn this stuff is from a bunch of bad experiences getting lied to. And then you'll start to learn, oh, that's where I messed up that or whatever. So it's more of an art than a science, quite honestly.
Right. I mean, even Amber Jones was answering to some of these YouTube people. And, it's just, they're very mean individuals.
Yeah.
I just feel bad for her.
Well, and that's the environment that she started in with this whole thing with her kids in the first place. She grew up in that type of environment, which is like, I mean, that's part of the joy of growing up in a narcissistic household that way. which is the problem when the family courts are indoctrinating the narcissistic policies onto these families who already have some that's going on. I mean, that's why narcissists do so well in the courtroom, because they naturally just acclimate themselves to those types of policies, because that's the abuse they grew up with. It's abuse home style. So they're very familiar with a lot of that. And I think that's sometimes why the abusive judges favor the abusive parents, because the abusive parent won't be calling the abusive judge out for their garbage, whereas a truth teller type of scapegoat role child or a grown adult who was a child in that position, they will obviously have issues when they come up into the abusive court system. So that's part of why that whole thing ends up happening that way. It's kind of baked into the cake once again. So but let's go on to Larimer County specifically, because even though Amber's had a little bit of overlap with Larimer, a lot of it was handled in Delta County. So Larimer County itself seems to be a hotbed for a lot of these types of issues. Just recently, and this is even with Colorado's media that is so bad to cover a lot of these things, there have been a slew of stories all surrounding different court officials and contractors from Larimer County specifically. And it's all been like in the last 2 or 3 years, I think we've had
got another case to talk about.
Excellent. I will share my screen here, and then we will start talking about the Sandra Spraker case from Larimer County. And I will share my screen while Rosemary can get us started with some of the explanation here. So Rosemary can probably correct me as we get into this, but what we have here is Sandra Spraker was a Larimer County caseworker who was committing fraud and filing forms incorrectly. All kinds of, well, here from the headline, reimbursement requests and other crimes while working as a caseworker. So the issue is she was given, this is more of a story about the accountability. Obviously, there's lots of corruption happening there. What makes this unique is they caught her, and they charged her with 99 counts, and they were felony charges to start with. These were major charges. And then through the court procedure, we find that this caseworker is now only going to get a slap on the wrist and was able to do a plea bargain to only 2 of the charges, and both of them were dropped to misdemeanors, if I'm not mistaken. Is that true, Rosemary?
No, she was convicted of a felony, 1 felony and 1 misdemeanor.
At least that's stuck. And in fact,
with no jail time, 1 day in jail.
How's that happen?
Well, she had to write a strongly worded letter of apology to the parents, I think.
Oh, to the parents and to the community. But what parents? They've never been named. They've never been identified. She did. And I even contacted the sheriff and said, hey, there's more. There are other cases, and have you talked to other parents? No, only the 10. But the response I got from the sheriff, and this was back in January, like within a month of the charge, and that she had nothing to do with, just to confirm that she had nothing to do with them, right? But they didn't want to know about the cases she was actively intervening on and making decisions for and recommendations and writing reports. They didn't want to hear about the real stuff, So the sheriff told me that they had 99 charges. That was enough, and that investigation had been closed. This was within 1 month of announcing the criminal charges in a press release. I reached out right away. No, it's closed. We don't want any more. We got enough. And I tried several times to say, but there's more and similar. You could add to those charges. But my concern was, what about the department not giving you all the information to do a full investigation. They chose not to provide families who could testify in addition to what the department did and going over their records and making the decision. This is what we're working with. I tried the DA. I said, hey, you've got more families out there. Why don't you reach out to them or ask the department to produce a list of all the cases that she worked on? Because they're not answering me, nor would the Board of County Commissioners get involved. Well, no, it would mean that they would produce information that implicated themselves, because those were the managers, those were the supervisors, the administrators that are in place to make sure this doesn't happen. Instead, they took full credit for finding the problems and dealing with it. Mm-hmm. And it was a one-off thing, and this never happens. Caseworkers are always truthful and honest and reasonable. That was the narrative they wanted us to go with. And there were no safety concerns anywhere in the year and a half she was employed with us. So she was just barely off probation too, handling cases as an ongoing caseworker. So she got the plea, and there was a sentencing hearing, and we could not get anyone to contact this mother of the family that had safety concerns as a result of. The DA didn't want to hear it. The sheriff didn't want to hear it. The department wouldn't go there. They won't talk to us. And so she wrote an affidavit and submitted it to the court clerk like half an hour before the sentencing hearing, to say, hey, what about me? The judge had to listen, right? You would think. The judge accepted it. She explained who she was, that her attempts had fallen on deaf ears, and that there were problems, and she wanted the judge to know. And there were probably others. We just don't know. The judge postponed the sentencing, admonished the DA, and told him to go get with the sheriff investigator and figure it out. So there was that was on November 5th. And December 5th came back to court, and reluctantly the DA had made a phone call to her. They really didn't want to know. I mean, this was an embarrassment to them that somebody would come forward in the 11th hour. We had tried before many times, and they didn't want to hear it. So the DA offered in his phone call to the mom before the December 5th sentencing hearing, as ordered by the judge. He said, I don't think there's criminal stuff. You probably have some grounds for some civil stuff. Why don't you write a victim impact statement and give it to me? I'm like, she did. She wrote a great one. And it was the same summary of a rubber stamp of before. Well, I don't think you were really a victim. We don't see, except, well, there is one thing. There was a gas voucher that she said she gave you, but she didn't, and she spent it. Well, okay, there's one little thing, right? Mm-hmm. We told you that a year ago. But that would be a criminal thing, and gee, we should let the sheriff know that there was something. But for this sentencing hearing, we're going to move forward and have the defendant get up and tell her sob story of how bad she felt. And the judge admonished her for all the safety concerns that could have arisen. Well, they did, but we're not going there. And it embarrassed the department and the justice system. I believe she used the term scar. It's a scar on the justice system. Well, it was a big scar on CPS, and they're not accountable. She got
They don't even
Was
mention
it?
the families. The
No.
families got
No.
scarred, and they don't even mention them. That's not even an afterthought.
The DA said there are no victims. It's not a Victim Rights Act case. She worked in child welfare, for God's sakes, right? Who was she?
And 29 of the counts were forgery of government
Yeah,
documents. That
yeah.
that doesn't go over well.
Those are trails, records, and letters to the court with recommendations about what they should do about a family.
Yeah.
Trails records is considered a legal document. They can't lie on those things. But I bet in every family that could ever get their hands on it would say that didn't happen. That's not true. I didn't say that. It's a mess.
Mm-hmm.
She got what'd she get? 3 years probation and 60 days jail to be served alternative sentencing work release. So she doesn't really have to go to jail. She just shows up on the weekends and does her time. It's odd because she doesn't have a job to leave and go to, but that was her sentence, basically.
So she spends the weekends in jail and then is out for the week.
Yeah, so she can go to work. Well, no, she goes, quote, goes to work during the day, comes to the separate jail unit with a bed just for those people at night. And then in the morning, she can go home. And then she comes back at night. So, I mean, I feel bad for her, but I feel angry that the department has avoided all culpability here, that there were problems. They did not recognize them soon enough. They didn't take responsibility for missing them. They didn't notify the court systems that there could be some faulty recommendations by this caseworker, that those parents deserved another look at decisions that were made based on her recommendations. Were there any safety risks? Yeah, there were. And that's this mom I know I've been working with, Carrie, couldn't get anyone to listen to her. Rather than launch into it right now, it's very concerning that they would allow the kids to go from safe mom custody to abusive dad custody based on false allegations that he presented in a DR case to get to an emergency or hearing for getting custody back to him. And this is a guy that's been to prison. He's had child abuse and domestic violence, extremely narcissistic, that you got to have training to read this guy. He's made threats that he would, if he had to go back to prison, he would not. He would take care of it. He would do himself in and probably take his boys with him, and he would like his ex-wife dead as well. So subtle, the harassment and intimidation and control that he's doing, even though she left the state just to save her life, to get away from him. But the department has had no response, no accountability, no interest in recognizing what happened here in this case, trying to rectify it. No apologies ever, no admissions, and no restitution or attempt to fix it. They just want it over with. Her case is scheduled to close next month, probably CPS case, but it's been such a farce how it got started, and they won't back it up to make it right, to say, oh, he lied about this and that. Mm-hmm. And the judge bought it.
Well, Rosemary, let's consider for a second that if they were all working together, with that being their original agenda, everything makes perfect sense. And that's exactly what was admitted in the Robin Niceta written admission, was that they had judges that specifically worked with the teams to accomplish those very type of results. And this is what we were touching on earlier about how the courts, being so narcissistically driven, they prefer the abusive parents.
Yes. Oh,
and
yeah.
There's obviously a pre-conclusion that when somebody comes in with abusive qualities, we want to give the kids to that parent because statistically it's more likely that that parent's going to mess up, and then we get to take the kids away from that parent, and now they're in foster care where they make the most money from the kickbacks. And that's my hypothesis. Obviously we don't have validated proof of that here, but it just keeps happening over and over and over and over in multiple counties and at the state level. And so it's undeniable at some point that that's at least something they're working towards, or at least actively not working at all to prevent. Because like what Rosemary was saying, if you were trying to protect that family, you could have done a million different things than what they chose to do, right? They've been preferring the abusive parent.
That's all I hear.
After the kids were placed back with the father, and mom had, had to have supervised visits and then okay visits, but it was such a turnaround from what was okay, except for what dad fabricated and made it look like not. Dad actually choked one of his sons a year ago, and the son was able to get away, left, and went to an emergency room. No charges resulted. And I got to say, law enforcement has, this guy has the ear of and sympathy of law enforcement too, thanks to Spraker, who said on another 911 call, and there've been 20 calls to this address in a year, 911 calls with dad. He's not doing great, but nobody will admit it. Sandra Spraker had been at the house when the law enforcement came one time, and she said, it's okay. It's okay. It's just a father-son conflict. And there's nothing here. It's okay.
It's like, one of those routine choking things you just hear about every once in a while. It's no big deal. It's just totally normal.
Oh yeah,
it's like what?
They
none of that even makes any sense.
They call it every parent has a different parenting style. That's
right. That's just a more assertive parenting style there.
Yeah.
He's doing his best. He's trying. He just have difficult kids.
Well, that's where the judge should be poking their nose into it and saying, wait a second, something smells fishy here, right? That's where you'd want the judge to be doing that, but they don't. That's the problem. One thing that I wanted to note with Susan Spraker, and maybe this can be a segue over so we can try and talk about the Lovejoy case also. Spraker's, this may or may not be true, actually, because I was just noticing there may be multiple Judge Deans in Larimer County, because we had Judge Lori Dean in Don Lovejoy's case, which we're going to get into in just a second. Yeah. And I believe the statement in here was, it was accepted by Judge Sarah. Oh, this is Sarah Cure, but we had her in Don's case too, right? In Don Lovejoy's case?
Correct.
So there's a lot of this where the judges are all sharing things too. So and Sarah Cure was probably one of the problems, because Lori Dean was the one that actually gave Don back his kid, I believe. So Sarah Cure may have been one of the ones we were having problems with earlier, because the Lovejoy case was fraught with issues. Did you have anything that you wanted to wrap up on with the Spraker case, or we could?
Well, this chapter is not closed because we're still fighting for this mother to be heard. We are still asking questions. We're still raising our hands. We're trying to get, how far do you go if the DA and the sheriff are all okay with, and the county attorney? Yeah. So it's a lot, but just thank you so much, Maryann, for having this forum to speak some truth about what parents are dealing with. I can't thank you
Rosemary,
enough.
on the note you were just making, here's where it goes after the sheriff and stuff. The lawmakers, right?
Right.
So the lawmakers here are saying they're presenting a sweeping legislation to overhaul Colorado's child welfare system. Now, you don't do an overhaul when things are working properly. You do an overhaul when things need to be scrapped and started over.
Right. Look at the date on that. That was over a year ago.
Right.
And
So they already did it, right? So everything's working
yes,
smooth then at this point, right? Because
no, they
these
had to
people
have
are
a
working
convene
on
a
it.
study committee over the over the summer. And they hashed out a lot of issues, a lot of problems, heard from many, many parents with a 3-minute timeline. Shut up, your time's up. But
Yeah.
they're aware of the problems. There were bills proposed. They were limited to only 5 bills can be introduced as a result of whatever you have heard and want to fix. So there was no way they were going to Band-Aid, do more than Band-Aid repair on a system so broken. But
5 band-aids, actually.
5 Band-Aids, yeah. And
Right.
those are the proposed bills that they'll be presenting in January.
But they present these bills and then no one follows them, these laws.
Well, the other problem with stumbling block for parents getting justice is the state rules and regs the Department of Human Services operates under. They're not the statutes completely. They have a whole set of, well, let's make our rules for when this happens, and let's make up our rules for when this happens. How are we going to address it? It's not so
Or,
much due process fixing those glaring problems of family
right.
courts and a preponderance of the evidence. It's like right now they have a decertification process work group that was appointed to convene after Nacetta and Spraker. And there were others out there in the state that were caught lying and fired. Some did not even have criminal charges. They just got to resign from the department and go away. But now we all see it's not just a one-off. The decertification process committee is all State Department administrators talking about what do we do when a caseworker is this bad, and how do we make sure they don't just go apply in another county, because that has happened.
Oh,
No
yes.
consequences. They don't lose their certification. So now they're hashing that out in great detail. I got to say, it's far more detail than a parent is allowed when they're accused and put on trails and try to defend themselves from that. But so there are efforts made by the State Department of Human Services oversight board. But again, they're just rules. And if you break rules, what are the consequences for
More importantly,
accountability?
Rosemary, let's look at the point here. Rules are not laws that are created
Right.
by the legislature. These
Right.
are products of the admin, the deep state, the blob,
Yes.
unelected officials making up these things that then supersede the actual laws. That's why we got the problems in the first place. Because
Yes.
quite frankly, if they were just following the Constitution and the laws that are on the books to start with, they wouldn't end up in a lot of these situations in the first place.
Right.
Like the Victims' Rights Act, that would probably be unnecessary if you were actually applying the Constitution in a lot of regards, right? There'd be a lot of cases where that might not even come into play just because they wouldn't necessarily have victims, or the victims would have been able to present their sides. And that's part of the problem with a lot of it. And it also underscores the point that they play these games and spend a lot of money on a legislator that then is going to create these wonderful laws that are supposed to fix things. But like what Maryann's saying, if they're truly lawless in their practices, when they're actually at their desks doing it and they don't follow the laws, and the judges will say, well, that law has no jurisdiction in my family courtroom because I'm going by maritime rules, or whatever crazy hokum they're using these when they're conducting themselves. Changing laws doesn't really have any effect until they can become more accountable and use the psychological fitness for duty standard, because that's the thing that truly would make people more accountable. But they have to enforce it. They can't just have it as pretty words that they have just to clear some checkbox.
One comment I'd like to make about civil court, which is family court, is that parents try to challenge their due process rights but it has to be a civil filing in district court, like a lawsuit. Parents have to turn around and sue the agency, the workers, etc. And I see county attorneys who are very adept at having those eventually dismissed.
Mhm.
And the reason being often the immunity clause, but caseworkers do not have government immunity full protection. They have, what's the term? It has to be, if there's harm done and it was knowingly done, then you are liable. If you stepped outside of your lane of what you're supposed to do in your job as a caseworker, if you went outside those boundaries, then you are liable if harm resulted. And county attorneys will fight those challenges tooth and nail to discredit the parents, and who had to hire another attorney to just get some justice. It's not easy to get justice when they mess with your families.
Mm-hmm. Yeah, it's just a bunch of cases all get dismissed, swept under the rug. What is up with the Don Lovejoy case?
Nate?
I wanted to share here. Hopefully it's working now. It says it's still loading it. This is the Larimer County mission statement. So when there's the mission statement from Larimer County, and you can see right here, so to provide safety and support for children and vulnerable citizens, which I'm sure Rosemary can attest to is just a farce at the point where they take it to when they're weaponizing things against parents, right? And then down here in the guiding principles, like if they're not doing these things, you should be able to hold them to it. And so part of what I used to do is ADA request that the department, when they respond, adhere to their mission statement and values. And the ADA is supposed to give you full access to government services under the law. So asking them to follow their own mission statements to make sure that they comply with your disability, that's totally within the grounds of what the ADA can cover. And it's not unreasonable or cause any unreasonable hardship on the group to follow their own mission statements, because that's what they should be doing in the first place. And so I would make the point then, if they were not psychologically fit for duty, they don't qualify as a qualified state employee, therefore do not qualify for qualified immunity. And it's a whole nother way to go about getting to that same argument. But right here, you can see partnerships with, starting on guiding principles here in number 2, partnerships with our customers and community. That's not happening. Results, outcomes-based decision-making, they work against that. Unless, maybe the results they're after are opposite of what the parents would want. But it doesn't jive with the rest of their points here. Here's one that's going to be just an outright joke for Rosemary. Hey, Rosemary, transparency, accountability, and confidentiality.
I'd say confidentiality, they do well. They say they can't talk to anyone about anything.
They weaponize it. Yeah. It's not done in the truest sense of the legalities. They weaponize it so it only works for them and against you, right?
Right.
So that's not really the same. It's like they should share things. And continuous, here you go, Rosemary. They don't even need the legislature because they are continuously doing quality improvement.
Continuously. They're always fixing. It's such a good system.
Mm-hmm.
Wrong. No.
Yeah.
Okay.
So that's the problem, though, is they just aren't adhering to their own standards or qualities.
No, it looks good on paper, though.
Right. And that's what I'm saying, where they just are checking things off of a checkbox rather than actually doing the things in practice. And then they would avoid a lot of these big issues. But that's why they keep doing it, is because they are trying to get those results. Mm-hmm. There's a point where you just have to, everybody wants to always give them the benefit of the doubt. They don't deserve it. They do not deserve it. Like in this application here. So like it's a thing where the government has just gone about weaponizing these cases against people. Mm-hmm. And do we have time to actually get into the Lovejoy case, Maryann?
Sure, sure.
Okay, because yeah, while I have Rosemary here, this is really good because both her and I worked as advocates on the Don Lovejoy case. In fact, Rosemary should set this up because she was working on it for years before I ever got onto it. I was a special request by Rosemary to help out with this.
Well, we actually have two different cases, and I think you wanted to address what happened before when he tried to address his son being placed in the seclusion room at the public school, right?
Yes, I that's where it started, basically.
Started there, yeah. He made noise. He was outspoken about the harm his son was experiencing when the school district was placing him in a seclusion room. The state has addressed seclusion rooms somewhat since that, but he was pretty much shot down by the department because they did not want to take on the school district. It was a defensive thing. But he had a name as a protected parent already in the community. What brought the newer case was allegations from, well, again, who's vetting them and at what level of clarity and legality are you giving someone the benefit of the doubt when they're accused of something. It was a result of an incident involving his daughter in high school who had left school grounds with a boy. She was not allowed to do that. She did it again. She was late for school coming back, and she has autism. So when pressured and in trouble, that's a whole different response from people with Asperger's or autism. The school jumped all over it because her boyfriend said, you should say that your dad did something to you. That'll take the heat off of you. And that you were late for school. We got caught. That's what started this whole dramatic circle the wagons around this poor child who's implying that her father sexually abused her. What happened after that was very sad because they immediately isolated the girl, and apparently she was not even able to write this or to speak about what happened. She had to write it down because it was so traumatic, right? I don't know. But they arrested Dad based on that interview, and he spent 2.5 years in the county jail waiting for his day in court. 2.5 years sitting there waiting while CPS took custody of her and his oldest Josh, maybe 10 at the time. 10.
I think around 10. Yeah.
They went home. Josh went to residential treatment centers, mental health institutes. He was struggling very badly while away from his dad. Mom's not in the picture. Mom's completely gone. Don never admitted to the allegations. He fought, but what happened to him in the family courts as a result of him being incarcerated and unable to actively participate in his own defense, we had an appointed attorney who made the admission for him because he was sitting in the jail. They didn't transport him. No, they might have transported him to that. No, he was appearing by video.
He had to appear in the pod from the jail is what I remember with that hearing. Go ahead.
But he has a hearing disability. The hearing aids were not always operating correctly, or they would put him in a room with background noise, no batteries in his hearing aid. He couldn't hear. It was just like, how do you not see that this is not fair?
He was in the general population to do the hearing. They didn't even give him a separate room. He was in the general population to do his hearing, to talk about his son. So he's like inviting all the other inmates within the jail to listen to his court case while it's going on about his minor son who's not in his custody anymore. Like there's so many like liabilities that they opened up through doing it just that way. I was actually brought in because of some of these disability issues.
Right.
And part of this, just to add on, I'll throw it right back to you, Rosemary. Don was asked then to agree to a plea bargain that he was unable to read because
now that was in the criminal case. We had two cases, the child welfare and the criminal charges, which were lengthy and serious. Oh my goodness. Yeah.
But they didn't even have any original charges on him, right? And the original evidence was done away with because it was found to be inaccurate or unusable. And so they dropped it, right?
Later in we're talking 2.5 years here, and different attorneys coming and going.
Right.
There was a lot of problems.
But he was basically unable to, he had to take the plea bargain while his hearing aids were not working. So no one could explain it to him. He couldn't read it because he didn't have his glasses. He had to do the whole thing under pressure, under a time limit by the judge. The judge is like, you have 30 minutes to review this and then agree to it or not. And the one factor that we need to really underscore here is that his son was in foster care at the time and had already been actively attempting unaliving on a regular basis. By the time to the end, it was like every 2 weeks he was trying a new attempt. And so Don was in this position where he was completely powerless to do anything about it, not given his hearing aids or his glasses, and had to accept this faulty plea deal when the county didn't even have any charges on him. That was the whole thing. And they were trying to force him to take the plea deal. Is that all correct, Rosemary?
Right. Yes. And the plea was really forced because the daughter had moved out of state. And the DA said they couldn't bring her back in time to prepare her for a trial. So they really had to pressure this plea agreement, which the charge he pled to was a co-ed charge, which means nothing happened, but you were planning to. That was it. A co-ed, CHOATE charge. That's the explanation. It's like, that's just a lack of accountability for putting this guy in jail for 2.5 years with no trial now, because you let the victim move away. Really, they were afraid that she would not testify well, so that's what he was dealing with. He just had to get out to fight for his son.
Well, and this points out the point I was making before, Maryann, how mothers, their playbook for mothers is, oh, she's a crackhead mom, we take her kids. For dads, he's an abuser, domestic violence, or sexual assault. One of the two, it doesn't matter. He's an abuser, we got to take the kids. And I'm not taking away from the stories where that's actually the case, but they've weaponized the false reporting of this to the point where these cases drive fathers' rights advocates just absolutely nuts, because they see this and they're like, well, then they tend to overcompensate and like try to give not all dads deserve that decision. It depends on if they're a legitimate danger to the kids. And I say this as a father's rights advocate. I often define it as I will always advocate for dads to get their half, but I don't want any one of the parents to be the dominating force over the other. And the other part is I don't want to see anybody putting false charges on each other. That's where I draw the line. And it's pretty easy to be an advocate that can still be a father's rights advocate and still look at where the mom has a position in this whole thing as well. Like I was saying earlier, I don't think it's actually a viable solution to put either parent in jail, regardless of these things. The solution should always be just supervised parenting time if you think they're a danger. And I don't even think the parents should have to pay for it. I think if that's a state solution, they should just have it provided by the state the same way they do if you're incarcerated, right? And they got all this money for police and stuff. Go ahead, Rosemary.
Oh, that's all. But a side note about being accused and incarcerated pre-trial in a family law case is that in Larimer County, and I would bet it's fairly consistent, but it's a county by county, there's no obligation or contract between the county commissioners and the sheriff's office to transport to hearings. So that's why Don had to sit and attend from jail with bad hearing and background noise. And sometimes he didn't even get to attend because the guards were busy. So that's got to change. It's not like those cases don't matter and aren't that important as a criminal case. You got to be there. You can't let your attorney run the show for you, not these respondent parent counsel attorneys.
Right. Where is Don now?
He's home. He's got his son back, and they're
Good.
doing so beautifully. It's so perfect. And I will add that the placement they had picked out for job placement before his rights were terminated, because they were going to terminate. They just knew they were right, and they were not right. But it was, I'm going to say it, two gay men, outwardly gay men, they were going to adopt him. And here's Don fighting for his son. I wish I had a picture to throw up and show you just they belong together. You know, things are okay now, but.
Well, one point that we can make to actually cement that whole thing in place is ever since we were warned ad nauseum by the department that it was going to be horrible releasing this child, you don't know what he's going to face at home or whatever. So that, right, exactly. It was comical. But to that point, what really happened then, as soon as CPS left him, he went home, never again had another issue with the unaliving attempts. Never again, not even a thought about it. They were playing Nerf guns or doing things out riding bikes or something like that. But it was never the issues that they were having and all the danger issues, like of the kid being hurt or molested, because there was an issue with this with the house that Rosemary was just discussing. Part of this whole thing is under the Colorado Children's Code. The CPS folks are supposed to put kids into culturally alike, that's the legal term, culturally alike homes. And Don was a devout Christian. He wants to homeschool his kid, the whole 9 yards, and he's totally allowed to do all that stuff. But part of the problem here is the gay household they were moving his son into was culturally opposite of where Don's training was at home. So by the Colorado Children's Code, they should not have ever chosen that home. Further, the home that they chose was in Aurora, back down by where Robin Nacetta is. And they moved the kid out of the county, and they're not supposed to do that either. They're supposed to place the kid as geographically close to the original home as possible to try to not make it as permanent of a thing, and so the kid could return if they wanted to. One of the big hurdles that we had legally with Don's case was that they kept having dual goals stated in the case. They were like, well, we're going to return the child home and look for foster care, which don't go together. Those don't go together. And this was so they could say to us, oh, well, look right there, we're returning the child home. But as they're booking appointments for him to go be at these other households that weren't correct by any measure under the Colorado Children's Code. And to the end, Rosemary left out one critical point about the county's legal case of this whole thing after it came out of the courts there. They literally did not have a case on Don. That was the problem when they came out of the whole thing with the plea bargain and everything else. There were no actual charges against Don. And the DA, even in one of the earlier status conferences for terminating his parents' rights, said the county is facing some absurd results. Those were his quoted words, absurd results. And that's because the county did not have a case on him. So Don wasn't even officially a party to the case because there was no official case Yet
Oh.
there's this DA working in a courtroom talking to a judge about the whole thing and saying, let's go ahead and proceed. And we need to charge him with something. Otherwise, the county's going to be faced with these absurd results, which meant they were going to charge a person with no charges. And how do they even do that legally? They didn't even know. And that was part of the problem with the whole thing. Not only that they were discriminating against him constantly, filed under false charges to start with, had no evidence. It goes on and on and on.
Mm-hmm.
And this is no fault of Rosemary. She's trying to recap like 5 years of legal BS in like 15 minutes.
Yeah.
And there was so much that was just wrong with this case. It was absurd. But the one thing that we can note about this is we came into this whole thing. Rosemary called me into the case. We battled with the CPS folks for about 6 months. And we basically tracked it all the way up the food chain to the department head in Larimer County.
Mm-hmm.
And we also had gone above her to the county commissioners, as Rosemary was touching on before, and they didn't do anything. No corrective actions have been taken at all in that case, as far as I know. Right, Rosemary?
Right. Oh, right. Yeah. Yeah.
That went under the rug as quick as they could sweep it there.
So he still has, we'll say, child abuse charges. Is he
Oh,
still?
no, CPS dropped at the end of this whole thing. They found out they have an absurd case going on where they weren't even a party to it, and then they had to drop the entire case after 1 month of the son being returned home. Please add on to that, Rosemary.
Well, I was going to say, Don got rid of his respondent parent counsel attorney who had been with him for that 2.5 years, and consideration, Debbie Carroll, consideration nonprofit.org, provided an attorney, Byron Miller, to come in and clean up the dirty work. And that's when they backed down and returned him home. So I give some credit to, changing the roles and bringing in somebody new and being willing to stand up and hang in that fight, because it was a long one.
It's terrible.
It shouldn't be so hard in these family court.
In that case, part of it, Rosemary went into the ORPC attorney. One thing they do in Colorado when a parent says that they're not able to proceed, basically, and Don had some issues with this because of his disabilities, and they'd actually tried to blame him for being incompetent to proceed at one point. So they brought in a special ADA guy just for Don to have as his ADA guy to take care of him. And this guy was one of the worst ones there too, just totally negligent with the whole thing. As soon as I came into the case, I spent the first little bit just educating the dude on what the ADA even covered and the ADAAA. So, and it was pretty bad. And so we kind of put that guy in his place. So that was one guy that got kind of taken out of it. But originally it was Don with this ORPC attorney who's acting as a bad faith actor, and then working with this adult GAL person who was there. And the problem with a GAL, whenever you have a GAL, your ORPC attorney is client driven. They'll do what you ask, but a GAL does what the state wants. And these are completely different agendas as far as how it goes. And so the GAL would be completely complicit with all the other forces from the county and work with them in tandem to make sure they end up with the results they wanted, which was taking the kids away from Don. So, but at the end, we disproved their total case. We called them out in every way to most of the managers. But part of this we also need to cover here, Rosemary, is Don was doing this for a long time working with CPS. His original caseworker was pretty dang crooked and ended up getting removed from his case, but failed upward and became the boss of his new corrupt caseworker. So we were having it out with the new caseworker.
What a mess.
And she, but hold on. The one that was actually contributing and exacerbating to his son's unaliving attempts was the CPS caseworker. like specifically was using her personal phone to call him up so there wouldn't be a court record. And then she was telling him, we don't still know what she actually was saying to him, but 15 minutes after one of her phone calls towards the end, he had another unaliving attempt. And so it was clear she was, and there was no other contact in between. And this is while he was at the group home.
Oh, terrible.
Right before we got him back and rescued him.
Right.
So one last thing I would like to present here for the, I don't know. Oh, I can make it bigger.
Yeah, there you go.
Okay. So the first thing you need to notice is the top of this picture that says Employee of the Month. It's kind of cut off a little bit, but this is Heather O'Hare. I'll see if I can get it in here and pull her up here so we can read.
She looks like she's 12 years old.
She referred us in Don's case to the ombudsman's office, which we talked about a little bit in the last podcast I was here, Maryann, about how ineffective they were at things. And we can do a deeper dive into them and the state auditors and all those other folks later. But at this point, we'd already alerted the county commissioner. Now, the important thing to know about this picture that's taken, and I should also announce, Heather O'Hare is the program director for the entire Larimer County Department of Human Services. Okay. And she's on this Employee of the Month wall. And this is the month before Don's son was returned home. And we'd been corresponding with her specifically for the last 3 months, to the point where she was trying to get rid of me and telling me that I was harassing her and some other stuff. And I wasn't harassing her. I was asking her questions that were completely within her job title, and she refused to answer them. So she has a role as the person who's the program director to answer for her employees. But we knew, at least with Don's case, there was the problem caseworker who was causing the unaliving. Then there was the old caseworker who was the problem working as her supervisor. So that's 2 layers deep already. Then the lady that was working as their team supervisor for both of those 2 ladies was also corrupt, and we were working with her, although we were able to flip her at the end. So she was actually working towards the return home at the end. But at the beginning, she was a stalwart supporter of the rest of the crew. And then so over top of her is this Heather O'Hare lady, who was the program director. O'Hare. Thank you, Rosemary. That's what Rosemary's here for.
Yeah.
So Rosemary took this picture while she was down there investigating. And the important thing to know about this is the same month that this happened was in July of 23. The next month, August of 23, is when the Susan Spraker story broke. And the one thing that they said in both of these were, well, especially in the Spraker story, because they had to do a public announcement about that. They're like, this is a unique problem. We don't have any other issues. This is a bad apple, lone wolf kind of thing, but there's no departmental issues. And we're here to tell you that it was absolutely rampant in the department. There's no accountability. So you had no idea how many other cases are going on. Even the ones that get out there, like the Spraker case, they aren't releasing who the victims even are. So parents can't organize and talk to each other. Got anything you want to add to that, Rosemary?
That's a very good explanation. Thank you.
Yeah, no worries. So this is the basic problem. And I was reading them the Riot Act. Like in Don Lovejoy's case, I was telling the caseworkers in there that, hey, under the FBI's definition of terrorism, you guys are terrorists. Like literally, they were holding his son at an undisclosed location, controlling all communication against the 2 parties, while he was in serious danger of unaliving himself on a regular basis. And it completely fits the FBI's definition of being a terrorist. Although they'll never use that term to describe themselves, but they absolutely fit the bill. And it was about 3 weeks after that it was shortly after that. It was like within 2 or 3 weeks after that they probably had the hearing with the attorney, where things just completely flipped, and they returned the kid home in 3 weeks after that hearing.
Goodness.
It went pretty quick at the end, but And an important thing to note for all the other parents out there, all the way up to bitter defeat, the county swore there was no way that kid was going home. They were adamant about it. That kid's never going back home.
It's so evil.
Yeah.
Oh.
Anyways, well, I'll stop sharing this, and
I'm so glad I had you both on. Is there anything else you'd like to add?
Well, you want to say, what does Paladin stand for? And that's your deal.
Oh,
Nate?
Yeah, we can add where
Okay.
we do information and stuff in just a bit. As far as the rest of this goes, Maryann, there is so much more. There were 2 more cases we didn't even get to go to because, like, clearly this would be way too much time. And those are only 4 of the cases out of this county. Like, they're constantly coming out, and there's new stuff all the time. And the state is just floundering trying to come up with answers for these things. But like, as we said, the issue is an accountability issue, and also just the state exercising the psychological fitness for duty standard. Because until they start enforcing that, it does not matter what new laws you pass, because they are lawless in practice, and they will just make policies that supersede the parts of the laws they don't want to apply.
Mm-hmm.
And so, like, it's really stuck until we can get some sort of accountability established. And the only way that's going to happen is getting accountable people in those roles. And the people that are there doing the leadership right now and oversight need to be replaced with people that can be accountable.
Mm-hmm.
And then you can deal with the caseworkers. But, like, it's when you try to deal with it in the way they are now, it's made to be futile.
Mm-hmm.
It's designed that way on purpose.
It is.
On that end, we can kind of wrap up for this one, because I know we've probably run long.
Oh, that's okay. I can put your details on how to reach you, Nate, as well as Debbie Carroll. And how about you, Rosemary? How do you want to be reached if anyone has any questions?
Well, what's the appropriate thing?
Well, I mean, they could come through me. That's fine too.
Yeah, I don't mind. I'm on Facebook. I'm with Debbie on consideration. I don't mind phone calls. I'll listen to anybody's story, and that's what helps us put the pieces together and define or identify trends, bad ones, so we can go forward and try and challenge. But well, I don't know. Find me on Facebook.
Okay.
The website for that is considerationnonprofit.org.
Yes, I have
Thank
it
you,
here.
Nate.
Yes,
Okay.
definitely.
Sure.
Okay. So don't jump off, okay? Slam the Gavel is a podcast to help the public understand what really goes on in these courtrooms. I'm your host, Maryann Petri, and you can find me on Spotify, YouTube. Please like and subscribe, Apple, iTunes, iHeartRadio, Google, and other platforms I don't know about. Again, feel free to buy me a coffee to help keep this podcast going. Thank you so much, Nate Munro and Rosemary Von Gorder. Thank you.
You're
Thank
welcome.
you, Maryann.